And we are live. I have three wonderful guests with me today. Happy Friday, everyone. I see that several people are already in the room waiting. The topic for today, why attorneys say to vote no on Proposition 22. And they're going to be talking about several other really important matters as well. Today, we welcome three California employee labor law attorneys who have been representing fellow rideshare drivers in their arbitration claims for misclassification against Lyft and Uber the past few years. They are local experts on the difference between employees versus independent contractors, the myth, fallacy that drivers are currently independent contractors, AB5, the California Supreme Court Dynamax decision, and what Proposition 22 is really about. They will also talk about what might change in the rideshare industry if Prop 22 passes compared to if it is defeated. They have also agreed to answer any questions that you guys have related to AB5, Prop 22, or misclassification, arbitration, or lost wages with the Department of Labor claims by drivers. So please type any questions you have, and I will ask them at the end of the session. Good morning, Iris. Good morning, Christian. And good morning, Aaron. How are you?
Hi, good morning. Thanks for having us.
Thank you for putting this time aside on a Friday. I know you guys are ready for the weekend.
They don't really run so cleanly anymore.
Indeed. Exactly. So I'm going to just jump right in. And the first question is, can you three tell us a little bit about how you work together? Maybe a little recap of what you have done so far with rideshare drivers. Feel free.
Sure. This is Christian Schreiber. So we are three lawyers. We work at three different law firms, but we've operated together over the last many months to represent rideshare drivers in individual arbitrations and in cases both in state and federal court. And we essentially have been litigating these cases to try to have our clients and classes of drivers actually reclassified as employees.
Yes.
We believe that the rideshare companies are misclassifying their drivers as independent contractors, and we've been very actively litigating these cases for now a couple years, and trying to basically bring justice for drivers and have both AB5 and the California Supreme Court's decision in the Dynamics case, made real for drivers.
Excellent. And I mean, a lot of people are joining up, right? They're going after their monies. There's a lot of money owed.
Yeah, it's true. I mean, I think as a percentage of the total number of drivers, it's still somewhat small. But the reality is that more and more drivers, as they get educated about what their rights should be, they become interested in pursuing their claims. And the good news is that we have also started to see, a tide turning in terms of getting the government involved.
Yes.
The Labor and Workforce Development Agency, the California Attorney General, the California Labor Commissioner, they've begun to weigh in on behalf of drivers, and they've joined the fight in a way that we believe is really helpful and potentially very powerful in helping to sort of turn the momentum away from this resistance that Uber, Lyft, DoorDash, these other companies have, just in the face of all evidence to the contrary, they continue to openly flout the law.
Exactly. And then what motivated you guys to represent rideshare drivers in arbitration claims instead of in class action lawsuits or filing through the Department of Labor? Because there's a lot of confusion on the, I get a lot of questions, do I go through the Department of Labor? Do I file a lawsuit? Could one of you three please clarify and explain that a little bit to our visitors?
Sure. This is Chris Schreiber again, and I'll encourage Iris and Aaron to weigh in also about their motivations. But just to answer your question, we represent workers for a living. We represent consumers, and our firms are civil rights firms in that we represent plaintiffs, usually against large companies. So we are, I think, all motivated by a sense of fairness, a sense of economic justice, and a sense that these are essential civil rights that we believe public policy in California supports, the California court system supports, the legislative branch supports, and so that's how we spend our hours. Just to clarify, we do, the three of us do represent drivers in arbitrations, but we've also pursued claims in court, including class action cases.
Okay.
And I don't want to give short shrift to the importance of that fight, because at the end of the day, arbitrations, are really a pro-corporate, anti-worker system. And the truth is, we have that fight as well at the federal level to try to undo the system of arbitration that that has taken hold for consumers and for workers. Arbitration is intended to be unfair to workers. It's intended to benefit companies. And so, yes, we do represent workers in arbitrations because that is the landscape that we have to operate in. But class actions are really a form of justice, and it can be both fast and much more fair to workers for lots of different reasons. But I'll hand it off to Iris and Aaron to sort of share their motivations.
Sure. Well. Thank you. Iris, go ahead. Thank you.
Yeah, sure. So I certainly agree with Chris on everything he said. I will just add the sort of practical point, which is that, the reason why we have filed so many arbitrations is that the vast majority of gig economy drivers have signed what are called arbitration agreements when they agree to the terms of service for Lyft. So unbeknownst to probably most folks, when you sign up to become a Lyft or Uber driver, included in that sign-up phase is your agreement to an arbitration, to proceed in arbitration for any claims you have. What that means and what the arbitration agreement says is that you are not allowed to file a lawsuit against Lyft or Uber, and you are not allowed to proceed collectively, which means that a situation like a class action lawsuit or even a collective mass arbitration are prohibited by the agreement. So unfortunately, we realize that a lot of drivers, and not just drivers, employees generally, are unfamiliar with arbitration agreements that are often presented at the very onset of the employment. But it often comes up in situations like this where you do realize you have some claims against your employer. You realize, okay, maybe you weren't paid fairly or you weren't treated fairly. And those arbitration agreements prevent employees from filing lawsuits and prevent employees from proceeding collectively often. And so and that's why we have so many arbitrations. I will say that there is sometimes an option to opt out of an arbitration agreement. So, yeah, I'm just putting that out there for folks, for folks who, carefully review any and all documents they're provided, including electronically, Lyft terms of service, for example, as far as we know, has an opt-out provision. It's very strict. You have to opt out within 30 days of agreeing to the terms of service. But
Yes.
some folks, are really thoughtful about that and know about the rights, and especially now that arbitration is gaining more and more traction and discussion, people are more aware of that. So yeah, by opting out of arbitration, you preserve your opportunity to file a case in court if you'd like, or to file a class action if you'd like. So
Yeah, that's
one way to do that.
That's a very, very important point. And each time, Iris, when the terms of service come out, I make a video day one and tell them exactly when those 30 days end. And the good thing is that people that love educating themselves, staying on top of matters, actually then use the language and opt out immediately. So this is what this channel is definitely about. That's why I'm super grateful to have you here. Aaron, do you mind chiming in on that question a little as well?
Sure, I'm happy to answer. When I first got involved in these cases, it was really looking like, after the Dynamex decision, to me it really looked like it was very clear under California law that rideshare drivers should be employees. And it seemed like the companies were using their arbitration clauses and the class action waivers in those clauses almost as a liability shield, almost to say, sure, you may be entitled to full reimbursement of all your business expenses under California law, but they're using procedural hurdles to make it very difficult to collect that from them. So I thought it was really great to get involved and say, okay, well, we're willing to pursue these as individual arbitrations if that's what it takes.
Good. And then a question to the panel. Can you speak to the issue of whether you consider current rideshare drivers independent contractors or employees, and why? This is a question I get via email and text every single day. Christian.
Actually, why don't I hand that off to Iris?
Okay, sure.
I'm happy to answer that, but Iris, feel free. I've been talking a lot.
Okay, yeah, sure. So, right, this is a very popular question, and really what we've dedicated a lot of our time to. So, certainly, I think that drivers are employees. It sounds like you are doing a great job of informing your listeners, but just in case folks aren't aware, just a bit of background. Under California law, there is a 3-part test, colloquially called the ABC test.
Yes.
And that controls whether someone is an independent contractor or an employee. And so in California, an employer has to meet all 3 parts of the test in order to classify someone as an independent contractor. And just briefly, basically the 3 parts of the test are: 1, whether the worker is free from control by their employer; 2, whether the employee works within the employer's main business; and 3, whether their worker has their own independently established business. Okay. And realistically, gig economy companies often can't meet any of those 3 requirements for many of their drivers, not to mention the requirement of having to meet all 3 to classify them as an independent contractor. And so, for us, I will just say, one argument we find especially strong is the sort of second requirement, prong 2, that requires workers to be outside of the usual course of the employer's business. So just to translate that, for example, if you're, say, a janitor working for a law firm, the law firm could classify you as an independent contractor because, the employer's main business is not janitorial services, it's a law firm. Okay. However, drivers perform the main business of gig economy companies. The companies want to argue that they're, quote unquote technology companies,
right.
Or like
Tony West,
an app company.
Yeah, Tony West's famous words,
right.
Exactly. Yeah, good.
But that I think that defines common sense and just our experiences with the companies, right? They're not app companies.
100%.
They're transportation companies or delivery companies. So drivers who perform the transportation and delivery services are performing the usual course of business for those companies. So, honestly, I think the writing is on the wall for gig economy companies. And that's why they're pushing for Prop 22, which is, what we're talking about today. There's been a lot of movement from drivers, as you know, and, the California government to hold gig economy companies accountable under the law. And again, maybe your readers know, or your listeners, know, but, the Superior Court recently ordered Uber and Lyft to reclassify their drivers.
Right.
In other words, they ordered them to make them employees, right?
Yes.
And the only reason it hasn't happened yet is that the decision was appealed by Uber and Lyft. And so that puts a pause on the implementation of the appeal. But, that's certainly why the gig economy companies are really pushing for Prop 22.
Right, yeah. They threatened to obviously leave the state of California. We knew that's not going to happen. Their number one market. And as you said early on, drivers took that as a big slap in the face when Tony West came out and told them, that they weren't part of the transportation business, but that they were just sort of tech workers working on their platform. There was major uproar when that happened. I remember people calling in and texting and emailing. They were truly upset, that they were being misclassified. Now, could you tell the audience what Proposition 22 is really about from your perspectives? Yesterday, there was a big day. Lots of people were live down there on Market Street in front of the HQ and Lyft. A big no on Proposition 22 protests. People were out in big numbers, and the media picked up on that very nicely. Obviously, that helps our cause. But briefly, if you could just tell the audience what Prop 22 is really about.
Sure, this is Aaron. I'm happy to answer that.
Thanks, Aaron.
From our perspective, I think Prop 22 really looks like the gig company's attempt to buy a special exemption from California law to avoid their legal obligations to their workers. And it looks like now they're approaching $200 million to put advertisements on for Proposition 22 in a way that seems to me quite misleading to the public to try to frame Proposition 22 as a pro-worker position when it really isn't.
Right. Exactly. Christian, would you like to add to that?
Yeah, this is Chris. I want to underscore something that Aaron said about the money. Prop 22 has proven to be extraordinarily deceptive to people who I think are even, are our natural allies. And I'll give you an example. I have a 17-year-old daughter. She will use an Uber or a Lyft app, and her father is working many hours a day, many days a week on behalf of drivers. And she told me a couple days ago that, it seemed like yes on Prop 22 was a good thing for drivers.
Oh, she said that.
I had to spend some time educating her.
Yeah.
And, she is about as proximal to, to somebody operating against Prop 22 as you can be.
Yeah.
Phone banking, litigating the case in lots of different ways and representing workers. So, these advertisements and the way they've characterized the proposition as ultimately benefiting communities of color and working parents and things like that, they're extraordinarily misleading. So
they are. I have a lot of
our work is cut out for us.
Christian, I have a lot of clients and friends that have been seeing these TV ads. They're flooding them all day long. I mean, $200 million buys you a lot of airtime. And but a lot of them reach out to me and say, Torsten, what's the real deal? You're in the business, so give us the bottom line. And drivers really need to use that opportunity, whether it's YouTube, Facebook, Instagram, Twitter. Get out there, educate your neighbor, because you got this one massive machine, right, that's just flooding $200 million worth of ads, literally brainwashing people, saying it over and over again. And then, on the other hand, we have a panel here of 3 attorneys educating Californians, educating the riders, educating the drivers on what they're trying to really achieve. That's also what my channel is about, is to truly connect with as many Californians and make them understand that they've just been, spoon-fed here.
Well, one thing I really want to get across about Prop 22 before letting, Aaron and Iris weigh back in on this, is that, the Prop 22 would create a class of worker that I don't believe there's any justification for. And let me give you an example. Right now, when a driver is out on an app, whether it's for Lyft or Uber, this time that they spend waiting to be engaged, right now, our position is that that's work.
Right.
That availability by that driver is something that benefits Uber and Lyft, and that's a fact. They want more people on the app ready to give a ride. Under Prop 22, the amount of time that you would be paid doesn't consider that at all.
Yeah.
You are paid for engaged time under this new class that would be created under Prop 22. And in addition, you don't receive the wear and tear mileage expenses on your vehicle that you're currently entitled to under the law if you're an employee.
Exactly.
So, the Prop 22 would effectively create a class of worker different than all others. And there's no real justification why drivers who are out on the streets providing a service to a company that makes its executives and its investors rich shouldn't be benefiting just as any other worker, who toils, on behalf of owners. There's just no reason why they shouldn't benefit in the same way with minimum wage, anti-harassment, anti-discrimination, workers' compensation protections, sick leave benefits, etc. So Prop 22 really is intended to strip those rights from workers.
Amen. Thanks for saying that.
And I just want to chime in to echo what was said, that getting drivers to really go out there and speak up and just share their experiences and views on Prop 22, I think is invaluable. I will say that I have also spoken to a number of people who say, drivers want Prop 22. That's what drivers want. Drivers want it because it provides them, flexibility, which is, seems to be the number one reason that's offered. And unfortunately, it feels like it's, Uber and Lyft and DoorDash, the gig economy companies who are speaking for drivers. It's their publicity that they're putting out there saying, we survey drivers and this is what drivers want. I think that it would be really helpful if drivers could, get their voices out there so that people who want to vote for what is best for drivers get the right messaging and not just the messaging from, the gig economy companies.
100% correct. I mean, the way they word it is, this is what drivers want, 421. These are their own surveys. So they're pushing out their own material. A lot of the drivers are buying it. Harry, the rideshare guy, a very good friend of mine who does a lot of online surveys, 65%, sadly said, they are, and this is not California voters, right? These are drivers. 65% wants this yes on 22. Why is it so high? And the reason is because they're being spoon-fed the same message through the apps day and night by Uber. I mean, they're doing a remarkable job, just like the pharmaceutical companies, the big oil. They've all bought their voters in the past. And it's just sad that drivers are not reading the fine print or really taking the time to educate themselves on this big, big thing that'll impact their lives. But yes, thank you for saying that they truly, truly need to share their knowledge with other with riders in the car, get into that conversation, right? Yeah.
Well, I don't blame the drivers, because I think the misinformation campaign is so pronounced. And, when your employer tells you that, you're going to lose your job if you vote for this, or,
yes,
we're going to leave California if this law takes effect, or if we start to follow the actual law, that's a daunting prospect. So it's understandable, but, one thing that I think has really been communicated to the public is that somehow flexibility is the function of being an independent contractor. And there's nothing that would prevent the kind of flexibility that drivers currently have if they were employees.
Right.
And that has not been identified by Uber or Lyft. Nobody has, from those companies, have come forward to say, oh, well, we can't allow this flexibility for employees. It's just because they can't do it. There is no reason why an employer cannot allow that type of flexibility.
Right.
And in fact, it's interesting because, in the pandemic, what I think we've seen is that a lot of employers have actually begun to reconsider what work looks like. And employers are no longer saying, hey, you've got to work 9 to 5. You've got to work in this manner. And the kind of creativity that, these gig economy companies claim to be noted for, they've really failed to put into play when it comes to, treating their drivers in the fairest way possible.
Aaron, do you want to chime in there on that one?
Sure. I think it's very interesting to me to hear these gig companies' arguments about flexibility. They have every incentive to create a flexible system. They compete heavily to get drivers on their platform and not on their competitors. And so it kind of rings false to me for them to say that if they were required to make all of their workers employees, that they would take away all of this flexibility, because since flexibility is something that seems so crucial to drivers, and since these companies compete with each other, it's pretty hard to believe that they're going to adopt some incredibly rigid system that their drivers don't like.
Right.
So a lot of this messaging that they're putting out there, a lot of these predictions that they're making about this parade of horribles they're saying is going to happen, it really seems overblown to me. Yeah. And at the end of the day, the companies are willing to put hundreds of millions of dollars behind this ballot initiative, which they wrote for themselves, ultimately because it helps their bottom line. Exactly. And it does so at the expense of workers.
Yeah. Now, what are the most likely changes if yes on 22 passes? And if Prop 22 is defeated, do you think Uber and Lyft will actually leave the state? Go ahead.
Aaron?
So I think if Prop 22 passes, then the gig companies have gotten what they wanted. They've avoided their obligations under the law. And for all going out into the future, they really don't have to worry anymore about being accountable to drivers or even to riders or the public. So, for example, if there was a car accident involving an Uber and someone got hurt, then if Prop 22 passes, Uber could point to the driver and say, "This Prop 22 says this person's completely independent from Uber, and this person is solely responsible for any harm that's come as a result of the accident."
Right.
It won't affect past claims. So
Okay.
for drivers who are currently in lawsuits suing the company, nothing in Proposition 22 says that it's retroactive. So it would only really apply to claims from the time that it's passed moving forward. So it won't affect the lawsuits that we have that are ongoing as far as time that's already been spent driving. But it would really allow the companies to avoid obligations moving forward.
So Aaron, if you could answer this question, if people are sitting on the fence, there's a lot of people too afraid to take action because they are truly scared of retaliation, right? I get this is a big one. They would love to sue for misclassification, et cetera, and we're going to put your details underneath the video afterwards. People are more than welcome to reach out to these three phenomenal attorneys that have your backs, and do they need to rally and get ready before November the 3rd, or do they have zero chances after election day? And if Uber gets away with this yes on 22, I mean, people really need to know this. Do they need to rally now? Anyone?
I think now is the time to rally as far as Proposition 22 goes. There was a poll from UC Berkeley that showed that it's polling incredibly close. There's a 3 percentage point lead in terms of people who support the yes position.
Wow.
But there's still 25% of the voters in that poll were undecided. So I think now is the time in terms of getting the message out there to their own networks, to voters that they know, and to anyone that will listen, to tell them the other side of the story, that despite all these advertisements they may have seen on TV saying that Proposition 22, a yes vote, is the pro-worker position, explaining that it really takes away all these rights that they have under current law, the right to have business expenses paid by the company and not forced onto the worker, the right to earn a subsistence, a basic standard of living in California, that it takes away many of these rights, and that no vote is really the pro-worker position. So I think now is really the time to get that message out there and to ensure that these companies are accountable to their workers in the future.
Okay.
And in terms of retaliation, for joining lawsuits, for people who've already been driving for these companies, they can join a lawsuit and their time that they've already spent, that shouldn't be affected by Proposition 22.
Okay.
I've never seen any of the companies retaliate against a worker just for filing suit against them.
Okay.
I understand that for people who are doing this as their livelihood, it can be scary to file suit, but I've never seen retaliation happening just for filing suit. And we'll often hear from people who say they've been terminated from the platform, but it's often for some other reason,
right.
And it's often difficult, as I'm sure you know, to get some of these platforms to explain their reasoning. But I've certainly never seen someone get terminated for filing an arbitration.
Okay. I have a question here from one of the subscribers. They say, question for the attorneys. Possible reason do you think police unions or MADD or other alleged driver YouTubers for supporting Proposition 22? Possible reason do you think police unions or MADD or other alleged pro-driver YouTubers for supporting Prop 22? I just can't understand. Can you? I mean, can you make sense of that question? Why these?
Yeah, sure. I mean, yeah, I can understand how these unions and how MAD has been co-opted into this big corporate fight. obviously we are part of those conversations, but I have enough experience in conversations like that to understand how they go. I'm quite certain that the pitch that was made to Matt was that, Uber and Lyft serve the purpose of keeping drunk drivers off the road. And I don't think anybody here is going to deny that.
Okay.
It is a valuable function of the rideshare companies that people who've been drinking can take a rideshare drive and as a passenger, and they can get safely to where they want to go. The leap that I think is the false leap to make is that Prop 22 has anything to do with that. What Uber and Lyft are trying to convince people is that if, for some reason, Prop 22 passes, that functionality or that service is going to go away, and now the streets are going to be flooded with drunk drivers. I don't think there's evidence of that. I don't think there's any reason to believe it. And I think that, Uber and Lyft have been engaged in a campaign to both the unions, the police unions, as well as to MAG, that, we're going to leave California, and that's going to leave the streets to run rampant with drunk drivers. I don't think, it's not as if these companies operated forever. We know what the situation was before. Have they assisted in reducing drunk drivers? I'm not sure what the evidence of that is, but let's assume it's true. Prop 22 doesn't mean that won't continue to be true.
Right.
So, and were there contributions made between Uber and Lyft and MAD and police unions? I don't know the answer to that.
Okay.
I do know that, many of these communities-based organizations did benefit handsomely from contributions by the companies. So, I think it's appropriate to be skeptical about
Indeed.
Why any organization is weighing in favor of Prop 22.
Now, do I have permission? Go ahead, Iris. Sorry, didn't mean to cut you off.
No problem. I guess I just wanted to echo what Christian and Aaron are saying, and maybe just add a slightly additional point, which is to say that, again, the kind of scare tactics that Uber and Lyft and, gig economy companies are using generally to sort of foreshadow, what will happen if Prop 22 doesn't pass. I think one, like Aaron mentioned, doesn't really appreciate the fact that, these companies rely on this business to survive at the very least. And if they have spent $200 million in California, it means there's some vested interest in California. Otherwise, they could have left, a while ago. They could have left when Dynamex came down. They could have left when AB5 came down. If this wasn't important to them, they wouldn't be spending $200 million in this market. And so, I think that there is vested interest here. And, also, the gig economy companies, Lyft and Uber and DoorDash, they're not the be-all, end-all. If it turns out that they don't want to comply with California law, that doesn't mean that the market has evaporated. There will still be need for rides. There will still be need for deliveries. And that just opens up the opportunity for other companies to come in who will comply with the law. And so, those jobs, those opportunities will hopefully still be there because, maybe that's what the consumer wants. And so, it doesn't have to be a choice between, the bad bargain we've got now or nothing. There is a third alternative. Either it's, reformation by the current gig economy companies or the introduction of some new companies that, will follow the law.
Yes, exactly, precisely. Also a question, do I have permission to leave your links underneath if people want to get hold of you? Because I see a lot of people rallying towards filing for misclassification. And they've truly been educated here. So can they reach out to you? Would you be able to send me the information? I could leave the links beneath the video. Is that possible?
Yeah, I mean, I want to be clear, I guess, our purpose today
Yes.
is really just to explain why we
Correct.
believe Prop 22 is bad. Obviously people who have questions about their legal rights, they can reach out to any one of the three of us. We're working together, but and we're easy enough to find. Happy to provide our information, but that's certainly not the purpose.
Yeah, no, they can Google you. Exactly. Another big one that I get, and back in the day before mid 2019, at least in the YouTube world, I was referred to as the referral king, right? It's a funny title, but I'd sent Juno about 13,000 drivers. I've sent Uber and Lyft probably collectively over 13,000 drivers as well. And then some way mid 2019, they just wiped out all of those grandfathered referrals out and wiped out hundreds of millions of dollars that they owed these top referrers. For example, in your city in San Francisco, there's a good friend, Rideshare report, and they literally wiped out $1.7 million in referral dollars. I had about $750,000 wiped out. Surely at the end of the day, somewhere, somehow down the line, drivers like myself and others, the people that helped build the company, should be able to go after those dollars as well, right? It is a completely different question, but this is one of my big ones, why I'm fighting them, because we've done so much for these companies, and just like they are so quick to misclassify drivers, they're also so quick to pull the rug under the people that have truly gone beyond and have helped this, this company, for example, have recruited in 900 cities worldwide, but they just don't want to pay. So interesting one. I'm just throwing it out there.
Yeah, that is interesting. Yeah, certainly different kind of claim.
Definitely. Cool. Good. So we got a lot of clarity today. I'm sorry I took you 10 minutes over the 30-minute mark. I wish the three of you a happy Friday and a wonderful weekend with your family. Stay safe over there. And on behalf of all the subscribers and the people that will be trickling in watching this video, a huge shout out and a massive, massive thank you to Iris, Christian, and Aaron. I really appreciate you being here and setting the record straight. Thank you, ladies and gentlemen, or lady and gentlemen.
Thank you.
Thank you, guys.
Thanks for having us.
Happy Friday. Is there anybody want any final? Or I think we covered everything, right? We covered a lot of good territory there.
Yep. Get out there, vote on November 3rd.
That's
Bill
it.
on 22.
Exactly. Excellent final words. Have a great day. Thank you so much. Bye-bye. Bye.
Bye-bye.
Well, that was wonderful. That was refreshing. I really enjoyed having Iris, Christian, and Aaron in our live feed. Nothing but gratitude. And I'll tell you why. Because as a driver, as a voice for driver, you need to hear it from the experts, right? Doesn't necessarily have to mean you have to believe it because I'm telling it. But if you have three top attorneys, all right there in San Francisco, right on their turf, giving you the ins and outs from a legal perspective, right? Breaking down AB5, breaking down Proposition 22, and I think they did an amazing job. They went beyond explaining to the subscribers, to our visitors, why it is so important to vote no on 22. Now, a lot of people in the room. Welcome, Robin. We have Robin and Robin Hood. We've got IQ Boy, Slick Nick, and a lot of great guests. If you could give our three guests a thumbs up, a like, let's pump up those numbers. Let's show them the appreciation. Just go down beneath the video, hit that like button, and a thank you, huge thank you for taking the time on your Friday just before the weekend to interact and connect with drivers. I wish you all a happy Friday, a great weekend. Thank you so much for joining us today. And you're more than welcome to Google the individuals or reach out to them. I'll leave a link. If you have any legal questions, they're up in San Fran. Anyone in California, they're just a phone call away. They have a 415 number. I'll leave the details